Thank you very much. I'm Adam Parachin. I'm a law professor at the Faculty of Law at Western University, and I specialize in the area of trust estates and charities law. And I've been invited today to talk about some of the legal nuts and bolts that you guys have to contend with in the trenches, as it were. And we've really got three objectives, or a couple of objectives here. One is to give you a little bit of concrete knowledge about the law. And another is to give you a little bit of a few things to think about. And the third is to point out how bizarre some of the status quo is. So hopefully we'll have some fun with that. Someone here knows what they're doing. When you invite a law professor, you always give a very clear time limit. And so I got it counting down right here. So let's start off with a few introductory observations on the charity versus politics distinction, which has obviously been the big talking point over the last 18 to 24 months in terms of legal issues in the field. As you all know, charity has its common law meaning in Canada, meaning we do not legislate the definition of charity in the Income Tax Act. There is a modest definition in the context of the Charities Accounting Act in Ontario, but that applies in a very, very selective capacity. And so charity in Canada is defined consistently with its common law meaning decisions of courts, not the four corners of a statute. And even at that, you'll hear a lot of lawyers and a lot of analysts talk about the common law definition of charity. Even that overstates the point. I think if you really want to understand what's going on in this area, it's better to perceive and approach the common law as providing a reasoning process, a somewhat open-textured reasoning process. 2 + 2 does not equals 4 is not what we have. We have a reasoning process where judges discover the law, or they find the law. And if that gives you the sense that it's relatively open-textured, that is the flavor of it. It's not a concrete formula. Now that sounds really problematic. We've got a tax concession system that provides tax receipts for people who make gifts to charities, and we define neither gift nor charity in the Income Tax Act. And that might be why the definition of charities attracted so much criticism. But here's the thing. It's probably the worst option except for all the others. And it's actually, as much as it's problematic, and we can't deny that, I think that there's much to commend it. And by extension, I'm not convinced that legislative solutions will actually make us and leave us in a better position. The definition of charity is a bit like the Constitution. You open that can of worms at your peril. And it's very difficult to just isolate one feature of it to legislatively amend. And for whatever it's worth, the experience of jurisdictions that have moved in the area of statutory reform are not necessarily any better off than we are. Here's a few head scratchers for you. On one side are charitable purposes, on the opposite side non-charitable. Providing a home for starving and forsaken cats, charitable. Seeking the abolition of torture, and I note there of human beings, not charitable. Promoting good housewifery, not my phrase, that's the testator's phrase in that case. Through an award for the woman with the best kept cottage, charitable. Promoting awareness of the social problems caused by pornography, including degradation of women and children, not. Okay. Ringing bells to commemorate the monarchy, very, very important, that's charitable. Appeasing racial tension, one court held, that's political. Promoting marriage among Jews, again, that's a quote right out of the judgment, that's not my language, charitable. Encouraging personal intercourse, again, that's a direct quote. You probably shouldn't use the word intercourse in your application for charitable status, but they did. Political. Providing abortion services, here's where we start to get really controversial. That was upheld as a health service and therefore charitable in every woman's health center. Promoting a view on abortion, though, too controversial. Okay, that's political. Education directed towards acceptance of the view that peace is better than war. A judge felt I can go out on that limb. Peace is preferable to war. But helping societies find peaceful ways to live together, that's political. Now you're injecting into the area of international relations. One of the interesting points you might want to note about those contradictions is none of the charitable purposes are themselves value neutral. I mean, they're not, and I don't want to have a discussion. They invite me to talk about charity. I don't want to come and discuss politics and abortion. But providing an abortion as a healthcare service is not value neutral on the issue of abortion. Whatever your view is on it, that actually manifests a view on the topic. In the same way that some of the previous slides, providing an award for good housewifery, I'm not sure that's entirely value neutral on the topic of gender relations and the like. And so one of the key points we want to keep in mind in this area is value neutrality in the area of charities impossible. And it's one of the ironies that courts have sought to attain to draw the distinction between charity and politics by striving for value neutrality. I mean, you can't define what it means to do good for others from a vantage of neutrality. And that's one of the issues that's caused so many problems in this area. Now, all of those purposes that I just mentioned that were characterized as non-charitable fell prey to the doctrine of political purposes. They were held to be non-charitable because they're political. And that's problematic because charities, in order to qualify as charitable at law, have to have exclusively charitable purposes. And here's how political is sometimes defined, although finding authorities for each of these individual propositions is sometimes easier said than done, frankly. Everybody agrees that promoting or opposing a political party or candidate for public office is political. And that's the least contentious one. More contentious in that category is what does it mean to promote or oppose a candidate? But in the abstract, everybody agrees that's properly characterized as political. Seeking a change to the law or policy of a government, political. Okay. Promoting a point of view or attitude of mind, there is some suggestion that is a political purpose, although there is an alternative interpretation that I would commend to you. Advocating in favor of one side of a controversial social issue, creating a climate of opinion. Some of the authorities have implied that these things are all political, and therefore if your purpose as an institution necessarily entails any of those, you risk not qualifying as charitable at law. Okay, and that's the problem, by the way, if we flip back to the earlier table, when we see at the top right that seeking the abolition of torture, the courts weren't deciding that torture is good. Seeking the abolition of torture it lacks public benefit because we need more torture, right? The judge was saying that term abolition requires law reform. Like, how would you abolish torture other than to make it unlawful? And because of that, that's what makes the purpose political in nature, is that it can only be achieved through law reform, okay? And so that's how you can sort of reason those decisions. Now, there's two ways for anyone to try and understand the law. One is to just memorize a bunch of rules. And if that works for you, you'll be one of the few for whom that works. The better way is to try and learn the rules. And then that way, you'll be better positioned to do some of your own vetting of legal issues. If you understand the basis for the rule, you'll be better positioned to apply it to your day-to-day operations. And so what is the rationale? I mean, it's one thing to just say, here's how political's been defined, but what's the rationale for that? And there's really two ways in which courts have tried to approach this topic. One is to try and categorize activities or purposes based on their substance, to look at the substance of what's being done and say, is that substantively political in nature? And you'd be surprised just how little of the case law actually delves into that kind of reasoning, where they look at a particular pursuit and say, by its very nature, it is inherently political. The one that comes closest to that is the idea that electioneering is political, where people tend to say, like, there's nothing more political than getting involved in a campaign. The more common way, and this might surprise you, the more common way that the authorities reason to the conclusion that a given activity or purpose is political is not on the basis of its substance, but owing to process concerns. And I'll explain what I mean by that. Look at the third bullet point. Here's how the reasoning works. In order to qualify as charitable, a given purpose has to satisfy the public benefit test. And courts have said that in the context of some purposes, we, due to political concerns of a political nature, can't say yes or no. We're not saying that the purpose possesses public benefit, neither are we saying the purpose lacks it. What we're saying is we can't decide, we shouldn't decide, right? Because it's not our function as courts to get involved in those kinds of debates. And so we're going to strive for a position of neutrality. Okay, and so that's how the reasoning played out in a case like Human Life International, where the issue was, is promoting the pro-life point of view charitable? And the courts would say, well, if it is, that must mean it's of public benefit. We can't find that pursuit of public benefit without blessing the pro-life point of view, and we just put our hands up in the air and say, I don't know. And the way that teases out in the judgment is, I don't know is not good enough for your charitable. I don't know by default means you're not charitable. You have, more literally, it means not found to be charitable. And so it's that kind of a process-oriented concern that actually really help you understand this area of law. If you want to know if a given pursuit is political or charitable, one of the questions is it the kind of pursuit in respect of which a court is likely to say, we shouldn't comment? Because if the answer is yes, you're probably in the political camp. Okay, and most people make the mistake, and it's an understandable one, of assuming that the law tries to categorize on substance. But it's not substance. It's a desire to preserve neutrality as to the presence or absence of benefit. And that's key to understanding this area. So another key point you want to keep in mind if you want to understand this area: no charity can have a political purpose. Because in order to be charitable at law, you have to have exclusively charitable purposes. Now get prepared for confusion. You can have exclusively charitable purposes, but engage in some political activities. Okay, so political purposes are always off the table, 100% disallowed, but some political activities are permissible. And there's a statutory basis for that in the Income Tax Act, and the provisions mentioned on the slide. But here are the restrictions. Substantially all resources have to be applied to charitable activities. So you can do some politics, but substantially all resources have to be applied to charitable activities. The political activities cannot include supporting directly or indirectly or opposing candidates for public office. And the political activities have to remain ancillary and incidental to charitable activities. So you can engage in politics, but only within those parameters. And so our definition of political activity corresponds with our definition of political purpose. Are you promoting or opposing a candidate for public office? Are you seeking a change to the law? Are you promoting an attitude of mind? And all of those tests parallel the tests for political purposes. So some of those activities are allowed, but only within certain limits. And here's how the CRA has defined the substantially all test. If your resources as an institution are up to $50,000, you can devote up to 20% of resources. If your income is up to $50,000, and you'll see the sliding scale on the slide. As your income goes up, the proportion of resources that can be contributed to political activities goes down. One of the significant problems with this slide is you'll notice that there's a disconnect between the use of the test being based on income, the institution's income, and then look how they define the amount you can expend on political activities. They define it as resources. And resources is bigger than income. It includes all of your resources, the CRA has said. And it's always been an open question as to how you quantify 20% of your intangible resources. How do you monetize a resource? And so that's definitely one area where the CRA could stand to have some greater clarity in the direction that they provide, because it's never been clear, as I said. How do you calculate the percentage of your intangible non-monetary resources? But that's the way that they've done it. Here's another key point on the political activities distinction that you should be aware of. You're able to engage in certain activities that you might actually think are political, but the CRA actually, I think somewhat surprisingly, characterizes as charitable. So for example, you can engage in the following with no specific concrete limitation. Representations to government that the law should change. Releasing to the text representations that you made to government, and even public awareness campaigns. All of those are characterized as charitable by the CRA, but here's the catch, and the devil's always in the details. The positions have to satisfy a well-reasoned requirement, okay? and they have to be connected and subordinate to the charity's purposes, and you can't ever, if you want to stay within the realm of charity, you can't have a call to political action. You could never end the representation with, and phone your MP and give them hell. Okay? That would qualify it as political. Now, the well-reasoned one is really the potentially problematic one, and I'm not saying that because I think we need more poorly reasoned public dialogue, but when you look closely at the policy document, the CRA defines well-reasoned to mean based on factual information. Factual information, which removes right off the table, if you read that literally, any form of improvable moral claim. That justice-oriented claims right off the table because they're not based on facts. They're not based on observable facts. They can't be demonstrated. And what you see there, if you want to really understand what's going on from the vantage of CRA, is they're striving for neutrality, right? They don't want to be blessing advocacy activities unless there's a neutral referent for the presence or absence of benefit. So facts give them that. Like if you're presenting an argument based on fact, they're saying, well, it must be right then, right? I mean, how do we know that? Well, it's based on facts, right? And facts don't lie. They're always right. Okay, so they're just looking for a neutral referent. But what I said, that actually removes right off the table any kind of moral reasoning, which is potentially problematic. Because once you actually start engaging in the act of persuading people to look at an issue in a particular way, you're potentially in the category of politics now. Whereas if you can buttress your arguments based on facts, now you're charitable. And I think that they've probably got that wrong. I think that's problematic, and I'm not sure that it's 100% supported by the case law. In terms of some future trends for you to be aware about, just quickly, there was an Australian decision you may or may not have heard about in 2010 called AidWatch, where the Australian High Court of Australia, effectively said that engaging in advocacy, even to the extent of criticizing government policy in the area of poverty relief, is itself charitable, as a discrete charitable purpose. You can actually be organized for the specific purpose of promoting a different kind of government policy to the public in the area of poverty relief. Now, they left open on how far, they left open how many topics that would extend to, but poverty relief can indeed be a basis for a public awareness campaign as a discrete purpose. Now, it took about 4 months for that case to be put towards the Federal Court of Appeal, and it was the Federal Court of Appeal in Canada declined to follow it. And basically, I mean, they always try and come up with a reason to distinguish the judgments, but read in context, it just says no. Right? That's the end. Now, they did leave a toehold for a future court to reconsider it, but so far they've rejected that. Shortly after that, Greenpeace in New Zealand, there was a decision from the Supreme Court there was deeply critical of this rule. The first half of the judgment effectively says we shouldn't have a restriction on political activities, and then somewhat paradoxically, the second half of the judgment says yes, we should. But nevertheless, there was the case there was really quite critical of the status quo. The big game changer, though, is going to be this issue of human rights. The first-tier tribunal in the UK just recently concluded that human rights-based constitutional litigation is charitable. And again, you understand why that is they go back to the neutrality principle. Courts don't have to be neutral on the content of human rights, because in the context of an entrenched charter of rights, courts interpret rights. And so this case, I'm 100% sure, was strategically created to take advantage of that definition of political, and the court concluded that human rights advocacy before courts is by definition charitable. Is that 5 seconds or 5 minutes? Okay. We can slow down then. This is good. Okay, and so that case is going to be brought to Canada. Like there's going to be some institution whose advocacy is challenged, and they're going to take the position that they're doing human rights work, and by extension, I'm therefore immune to that neutrality objection. Okay? And so the case really illustrates, and this is again one of those takeout points where you don't necessarily have to memorize the law, you just need to understand its rationale to do some of your own legal vetting. There's 2 ways to avoid restrictions on political advocacy. One, don't advocate. Well, that's an easy one, but some people would see that as a failure of their charitable mission. Okay, and so that's not satisfactory to everybody. 2, advocate in ways that sidestep the neutrality rationale. Okay, it's one of the ironies of current law that we characterize advocacy as political in many contexts, but then look at how we define charity on the assumption that there's no advocacy going on. Relieving poverty, education, religion. I mean, religion, of all things, provides people with a theological roadmap to form all sorts of views on a wide array of the most contentious of issues. But we bless that with the cover of charitableness because it's based on religious reasoning. But then, oddly enough, we don't apply the same reasoning to other morally based claims. But nevertheless, the human rights issue that's raised by this judgment, the CRA is going to have to contend with that. And what will their response be? If they open the floodgates, as they sometimes call it in law, and say all human rights litigation is charitable, then they will have effectively ended the rule against political purposes. And I say that because think about all of the cases in Canada that have dealt with the issue of politics, even the abortion cases. The pro-life organizations that were deregistered will just re-register on the premise that they're advancing the life, liberty, and security of the person of the unborn. And the court couldn't possibly respond and say, we have to remain neutral on the content of the Charter of Rights. I mean, that is potentially a huge game changer, that decision, once it'll be brought to Canada. So I know the Justin Trudeau platform included some vague reference to a statutory solution to the political muddle with charities, or a new statutory regime for charities. I mean, it's difficult to be positive or critical about it without knowing the details. I would say that I'm cautiously optimistic, but more cautious than optimistic. As I said, legal meaning of charity is a bit like the Constitution. You might find out that these were the good old days, if we end up with a new statutory system. And the one thing about statutes is statutes just invite further modification by the next government that you may or may not feel as comfortable with. So the common law, warts and all, might be the worst, might be the least worst system, as it were. I actually think if we were going to make a few changes here in this area of law, they would actually be relatively simple and can probably be done at the administrative level with the CRA. Thought leadership should be recognized within certain limitations as a discrete charitable purpose. Just because messaging is endemic to almost all charitable programming, even something as banal as a scholarship fund signals to the public a view about what kind of achievements are worthy of support. What kind of candidates are worthy of support and on what basis? Gender, religion? There's cases upholding religiously tested scholarships still in Canada. Gender-based scholarship, who's a disadvantaged person? All of those things are wrapped up even to something as commonplace as a scholarship. So the idea that charities don't engage in messaging is actually, I think, an ill-conceived and descriptively wrong idea. So there's a basis in current law for us to recognize thought leadership. And I think if we even went that far, that would be a significant achievement in the status quo. But there's a red light here flashing 000. And so I thank you for the indulgence of taking a few extra seconds.